Hi, my name is Liam with High Desert Law. If you're like most people, you probably have a few questions about estates, trusts, and wills. It's far too easy to get lost and confused in all the technical issues surrounding how to properly handle the estate of a recently deceased loved one. But let's see if we can clear up a few issues. It's often joked that death and taxes are the only certainties we have in life. And while this is true, the choices you make prior to dying can have a dramatic effect on what happens to your estate. To illustrate this, let's take a look at what happens when you die without creating any kind of plan. No will, no trusts, nothing. When you pass away without a will or a trust, the laws of your state will determine how your assets are distributed. This process is known as dying intestate, and it can lead to unintended consequences. Without a will or trust, your estate may be subject to probate court proceedings based upon the total value of your estate. A full probate typically takes about a year to 18 months to complete and can be quite costly in fees. In probate court, the court will choose who is best suited to manage your assets and handle the legal process. This representative acts as a trustee, following state guidelines to marshal and settle your estate. This means that you do not have any say or input on who will manage your affairs or how your assets are distributed. Worse, the appointed representative might be someone you wouldn't choose, leading to potential conflicts. After paying your estate debts and taxes, what's left over is then divided out to your next of kin. Each state has as its own intestacy laws that outline how your assets are divided. In California, the order goes like this: immediate family first. The law prioritizes your spouse and children. If you do not have a spouse or children, then your assets will go to your parents and siblings. If you have no close family, then the state guidelines will outline the order of your distant next of kin. Finally, in some cases, your property may be lost to the state. In short, dying intestate creates challenges for your loved ones. Without your instructions, they face the complex legal process of distributing your assets by means of a cumbersome legal process that is time-consuming and expensive. Additionally, this might not be the way you would have wished, and without clear instructions, family members may disagree on how the assets should have been divided. Now let's look at what happens when you have only a will. A will is a legal document that instructs who will be in charge of your estate and how your assets are divided. The will acts as a clear instructional guide, thereby eliminating potential confusion and disagreements. However, having a will only still requires that your estate go through the court process of probate. As discussed earlier, this results in your family having to manage the legal process subject to court oversight, delay, and expenses. So then, what is the best way to avoid the mess and hassle of probate? One word: trusts. There are many different types of trusts that range from simple probate avoidance to complex special needs trusts. All of them avoid the probate court process. Each can be easily customized to ensure they protect both your assets and your loved ones. We here at High Desert Law specialize in all trusts and estate planning and have assembled a top team of experts and resources to best serve you and your needs. Contact us today for a free, no-strings-attached consultation with one of our attorneys. You've worked so hard to achieve the things you have. Don't risk it all by leaving your estate exposed. Let us help you protect your estate and your loved ones.